arbitrary term. They are required on an annual basis to basically give an accounting of here's what we got in dues, here's what we spent it on. Plain and simple. Could be one page. In most cases, it probably will be. And an important aspect of citizen involvement is being able to shape the budget. So there's a provision requiring that the HOA has to pass an annual budget, and every resident of that would be entitled to some involvement in that process. We heard a lot of concerns about developers taking those HOA dues and using them for other projects, or even using them for parts of the project that were not common area. Maintenance of individual lots, for example, or legal fees. So there's a provision that prohibits the developer from commingling HOA funds with any of the developer's funds, and prohibits those HOA funds from being commingled with another HOA's funds. The developer is under control of more than one, and the funds can only be used for those purposes specified in the declaration. Any questions on this? Pay dues to the developer, but the neighborhood is still a mess. This is the worst one. And it's the one that we struggle with the most. So you're going to see a lot of tools for us. The most important one, and this is actually a provision that I've tweaked, and I've gone to other communities, other states for a little bit of reference. It requires the developer to share in the cost of common area maintenance during the period of developer control. And originally it said they share a cost as their portion of their unsold lots bears to the total lots. But I actually saw the state of Florida actually does it in a much better, cleaner way, and it's a little bit more fair to the developers to say either if there's 100 lots and 50 of them are unsold, the developer owns them, the developer has to pay dues on all 50 lots, or the developer has to pay the difference between what the association is getting in dues and their total expenses for upkeep of common areas. And I think pretty much every circumstance, maybe not every circumstance, but I think in the majority of cases the latter is going to be true. The latter is going to be what the developer opts into. But it effectively prevents the developer from saying, I am exempt from responsibility for the lots that I own. And that we hear that a lot. And because of that provision and because of the records provision, you should see in the statement of financial statement records indicating that the developer has paid those dues or has contributed that amount to make up the difference. Failure to maintain common areas is declared a public nuisance. I think that there's an argument that it was already that, but I wanted to make it clear. We expect those common areas to be maintained, and they would be subject to the same code enforcement process that regular property would be. A problem for common area for city code enforcement is the city's process is give notice, fix the problem. Let's say it's mowing tall grass. It doesn't get fixed. We mow it. We slap a lien on the property, and then what? The city, for one, the city doesn't want common area property, and two, a property with deed restrictions on it that say it cannot be developed has no market value. So no one's going to buy it. It's just going to perpetually maintain with no recourse. So this is one of those places where we're striking that balance between private rights and government overreach. What we say is, should we be required to come onto a property and maintain common area? that we would have the right to go to court and basically recoup those fees, recoup those abatement costs through all of the properties in that subdivision, like they were paying dues to a receiver, essentially appointed by the court. I think there is a real incentive there for neighborhoods that aren't getting maintained to come up with some kind of maintenance mechanism. We'll get into that later. And also, let's say that you have that neighborhood where it's currently under development. You've got a lot of common areas that aren't getting maintained. You hear a lot about subdivision signs and neighborhood entrances not being maintained. Normally, the developer has a incentive to make their property look presentable to try to sell lots, but sometimes things happen. Sometimes developments go belly up. It happens. Provision that we added, and I'll just be honest, it's unique. We authorize any citizen who is affected by a violation of this ordinance to go to court and seek an injunction. Let's say an ordinance requires the developer to do, this ordinance requires the developer to do X, and as a result of the developer not doing that, common areas didn't get maintained, or somehow the homeowners were damaged, property values were damaged. This does not authorize owners to go and seek damages, because we frankly can't go that far. But we can go as far as to say, look, this is a scheme that is meant to protect the general public as a consumer protection type ordinance, and therefore public has the right to enforce this in the same way that the city does. The city, of course, would have the right to seek enforcement through injunction. But we feel like that is again, it's incentive for homeowners to take control of their own neighborhoods and seek to hold themselves and the developer accountable. Any questions on this slide? Big one.
Andrew, I do have a real quick question. You were talking about the way Florida handles it. Does the developer make that decision like on an annual basis, or is it the beginning of their project where you said that they could either pay for the remaining lots or I guess the shortfall?
There's no specification, so it will be an ongoing decision. I think you'd make it on an annual basis when you were collecting the dues.
Right.
And the developer who's in control of the whole thing, through himself or through a board, says, here is our statement of expenses that we had to maintain the property during this year.
Right.
And
I would think as well on an annual basis, because the clock's going to start over.
I have a question. I'm sorry. You said that now that you passed this ordinance where these people are, the developers are required to have their, a sign basically saying this is a deed restricted community. So what about the processes or the buildings that are in construction now, that the apartment complexes that are 10 foot off my property line right now, things like that? So are they going to be also required to have that set up? And is there anything, does that rule apply to the people who are building now?
Yeah. And I kind of skipped over that. I was going to save it for the end, but probably should have hit that one right up front. The city does not have the ability to, no government has the ability to retroactively affect contracts.
This is only about.
So anytime there's a subdivision that has an approved development plan, approved plat, even approved covenants and restrictions, the city cannot affect those. We can affect them going forward. We can say from this point forward, all parts of the process have to be like this. We can also, to some extent, gap fill. So if we can go backwards in time and say, all right, we're not interfering with the terms of the contract if the contract is silent on that provision. If, for instance, there's a declaration of covenants and restrictions that doesn't set forth the election of officers. It ought to. The city ordinance requiring certain provisions for governance of an HOA could be applicable.
So if they don't have it listed, then we can fill it in with what's in this, is basically what you're saying.
That's the argument.
Okay.
That's the argument. And that is consistent with general principles of municipal law. Is that as long as we can say that we're not interfering with contractual right, that we're simply providing a framework and supplementing, I think those provisions get upheld.
All right.
So another question here. Good question.
So I'm sorry, I'm confused. Are you saying that, so we live in a colony, that we can't retroactively go back and start a homeowners association now?
I'll get to that one.
Okay.
I'll get to that one in a later slide. This is more about, the majority of this is about fixing problems going forward, because that's where our real power lies. So, but I will try to wrap that up and talk about which provisions are applicable to existing situations. All right, here's another one. The developer went belly up, and the remaining lots got sold to another developer or a builder. We've actually got a situation like this right now, where you had a community that was built in phases, and one thing or another happened to the developer, and the developer ended up either selling all of the lots, or they got sold by a court. I'm not 100% sure, but essentially now those lots, instead of being held by a developer to be sold to individual homeowners, are now held by one builder, who will act in a way as a developer, but really more of a speculator on building houses. So the developer's assigns and heirs are bound to the same terms and conditions of the declaration that the developer is. So if the developer says, I hereby transfer my rights to develop this property to X, X is bound in the exact same way. And that, when it's transferred to builders and contractors, they are treated just like any other property owner. They're required, and this applies regardless of what point it is. If the developer doesn't go belly up and a builder buys a lot, is going to spec it and build a house, they're required to pay association dues as well. But importantly, much like a developer, as we've said it in this ordinance, they're not entitled to more than one vote in the decision of whether to amend the declaration, to change the terms and conditions of the overall structure of the neighborhood. And based on our last ordinance that touched on HOAs, our common scheme of development ordinance, going forward, a declaration can only be changed absent a showing of substantial change in economic circumstances. So in that case where you have a phase, and that phase lingered and did not get built and ended up getting pushed off to another developer, or another builder, that builder can't come in and say, I'm changing the terms, I'm going to build different stuff, or I'm going to take them out of the HOA, or I'm not going to charge them as much in HOA dues. That stuff all has to be set forth from the get-go. And we kind of vetted that well, but we provided enough of that balance to where a developer can say, look, things really have changed, and here's the plan for fixing that. They would have to go before the planning commission and prove essentially that circumstances have changed enough to warrant that neighborhood being changed in whatever manner that they're proposing, whether it be a different HOA or a lot of these declarations are construction type, square footage, materials to be used. They would have to somehow show that some change in circumstances dictates that, or necessitates that being changed. Okay. The neighborhood sign is crumbling, no one knows who owns it or who is responsible for fixing it. There's people in this room, I bet, who are thinking about that right now. The problem is that, one, the plats and the declarations and the deeds don't clearly indicate what's common area. In the colony, for example, you've got that nice big stone foundation, gate, whatever you want to call it, that's out front, that keeps getting hit. And there's been a lot of history to it. Sometimes the city has fixed it, sometimes the residents have fixed it. But the point is that it's a spot, it's not on a lot, it's not in the right of way. Who's responsible for it? And this does two things. First, on a going forward basis, it requires all areas to be clearly indicated in the plat what is common area. And then it creates a presumption, a conclusive presumption, that if it's not a lot, if it's not infrastructure that the city has lawfully accepted, and it's for the benefit or use of the community, it is presumed to be common area. So we eliminate the question, whose responsibility is this? And I think that's important for a variety of reasons. I think in the case of the neighborhood that I'm thinking about, with the crumbling neighborhood sign, not the colony, the developer still owns that property. So, in that case, it's not gonna be considered a lot. It's not meant for sale to the public. It's not marked out as a platted lot, so it can't be marketed. But at the same time, it was never legally transferred in the way that it was supposed to be. So the presumption is gonna be, that's common area, regardless of what the title says, regardless of who owns it. If it was set aside by the developer for use and enjoyment of the citizens, of the residents of the neighborhood, and it's not a lot, and it's not, I missed a part, if it's not specifically excluded in the declaration, it's common area. It's a catch-all. All right, too big. Our HOA is run by a third-party management company with no respect for the residents' interests. I heard it came in over there.
We heard stories that we met.
Oh, yeah. I've heard some today.
Okay. I'll be honest with you, this is one where you got the balance. You got the developer's rights to control, you got the homeowner's rights to know and have their own control. So the third-party management model is extremely common. It's a way for developers to control costs. And frankly, developers want to be in the business of developing, not owning property.
Amen.
So they hire third-party management companies to keep order. And most of the times, these folks do a real good job. I guess the problem is sometimes they do too good of a job. But when it comes to things like enforcing deed restrictions, particularly lot sizes or house sizes or construction materials, they're important. They serve an important purpose. So the way I'd like to think that our ordinance most contributes to that is to require a timed transition from the developer control to the homeowner control. For developments of less than 300 lots, once 51% of the lots are sold, or 3 years after the developer ceases to offer lots for sale, or 7 years after they convey the first lot, the HOA has to be transferred fully over to the property owners. That is control transferred. And after 25% of the lots are sold, at least one and not less than 20% of the board members are elected by the residents. And after 40%, not less than a third of the board members are elected. So it's a way of recognizing that the neighborhood is transitioning from one under construction to one that is permanent and finished, without unduly restricting development. Also, and the top requirement here, requiring them to be held at locations convenient to the residents, I added that. It kind of hit me as I was going over this last week. That's one really easy way for residents to voice their concerns, is to be a part of the HOA hearing or the HOA board meeting. And if the HOA board meeting is in Cincinnati, where the third-party management company lives, that's not exactly convenient for the residents. So they have to have those board meetings here, near the neighborhood preferably. They have to get notice. They have to get not too much and not too little, 10 to 60 days notice. And 10% of the lot owners can call their own meeting. So you go next door to 15 of your neighbors, and you get them to sign a sheet that says, I hereby call a special meeting of the whatever neighborhood homeowners association. You mail that to the developer or the third-party administrator. They got no choice. You got to have a board meeting, at which you would voice your concerns over the tactics.
There's a question right there.
Not so much a question, but under this administration of the planned community and that 300 that you mentioned, I think the numbers are reversed. It makes no sense the way it's written right now for associations with less than 301 lots, and then the next statement says with 300 or more. I think the two numbers need to be reversed in the ordinance to make sense to me.
Which numbers?
All right, it's under number 5, administrative plan community. Let's see.
What I have is that once it gets above 300, then the time frame shifts a little bit longer. If that's inconsistent with what you got, I apologize.
Well, no, here, it says, under here, it says period of declaration of control. It says for associations of less than 301 lots, right? And then, under the second one, it says for association of 300 lots or more. And I
That should
think
be, you're right, that should be less than
reversed.
300 and more than 300.
Yeah, the numbers need to be reversed in those two.
Thank you, sir. You get in real trouble if you got a neighborhood that has exactly 300.
Yeah.
All right, good question. Any others before I move on from this slide? I think we're nearing the end of my,
That's a really good catch.
Yeah,
Thank you.
absolutely.
for that
Thank
detail.
you. You're welcome.
We spent a lot of time trying to figure out the HOAs behave differently when they're new and emerging, and they're in a period of developer control, working their way toward becoming owner controlled. And when a development is fully mature and the HOA is owner controlled in its entirety. And we've tried to build in protections for the homeowners at each of those transitional stages, because the needs are different for each of those transitional stages for you all to be protected.
I have a question. You were saying in the 300 lot or less, and the 3-year and the 7-year, and once 51% of the lots are sold, the homeowners association takes control away from the developer? Is that what I'm?
it would shift then from declaring control to resident control.
Even though the developer may have still 145 of the 300 lots he's to lose, or he or she, the developer, is to lose control of the homeowners association at that point?
Well, you know, and that's a significant point. That's a number for this council to consider. I think that I would add one thing to that, and that is, and I'm not an expert in HOAs, but it's one thing to say that a development has gone from developer control to homeowner control. It's another thing to say the developer has no say-so whatsoever. And the developer does have the ability to put certain conditions in that safeguard developers' interests. But your point is well taken.
Well,
Andrew, doesn't the developer still have a vote for each lot that they have?
Yes.
So they might not have control, but they still have their.
Democracy still works.
but if you're gonna require the developer to pay the difference for what you've collected in expenses, or what you've collected in association dues versus expenses, but they don't have the votes, even though they still have 145 of the 300 lots, who wants to develop? You're really exposing, developers are really exposed at that point of being at the mercy, even though they still have maybe a $5 million investment with those 145 lots.
You're saying they control what that ultimate bill is.
They would no longer control it.
Right.
Yeah. That's something I think that needs to be looked at more closely before it's voted on.
What percentage would be beneficial?
I don't have the answers.
Right.
Just raising that point.
That's why we're having the meeting.
Right. Now, I will say,
Those are the questions.
The 51% just seems low.
we did lower that threshold. Absolutely. The model ordinance called for a much higher threshold than that. And I think there's probably a way to balance that to where the developer still has the control that he needs to keep situations like that from occurring, but still give the citizens, the residents, the input that they need.
Thank you.
It's been so tilted in the opposite direction, Joey. We're trying to find the right place on the continuum.
I appreciate that.
But these conversations are helpful.
And I apologize. A lot of the statements that are coming out of my mouth are a little bit developer bashing. But they're the statements
We're used to it.
What's
they're
new,
the
huh,
statements
Joey?
we hear. All right.
But it's not all developers are bad now. We want to say that up front too. There's a few of them that we have issues with, but majority of them we don't.
And I also want to say that this is not a Georgetown problem. We are addressing this in a way that's unique to Georgetown. But this kind of issue, that struggle between developer wanting to have a fantastic development and needing flexibility to do it, and the citizens who live there needing some kind of assurance of the values of their homes and what their responsibilities are, that struggle plays out in every state and in every city. There's a reason why a bill that was very similar to this was proposed in the state General Assembly. It's because people are screaming about this. We just happen to want to take care of that. We want to take care of that issue for our citizens in a way that's fair for everyone. This meeting is about tweaking those numbers. It's about weighing in on those thresholds, because they're all over this ordinance. Those kinds of percentages for when certain things happen or why certain things happen, those things are infinitely movable pieces. And happy at any point to talk to anybody about how we manipulate those to get the right result.
Andrew, at what point did you say the developer had one vote? I heard that comment earlier. Under what scenario did that apply?
That's from get-go, solely on the issue of amending the declaration. And that goes back to, well,
Changing the deal.
that goes back to changing the deal. And admittedly, that's a very strong, standard. That could be misunderstood. combine that, that provision with the fact that you already have that common scheme of development requirement, I mean, I think it's an essential lockdown. Maybe when, and this is something that's just kind of occurring to me, maybe because there's so much protection under that common scheme of development ordinance that you back down that provision a little bit. But the flip side to that is the developer makes it such that the citizens have zero input on whether a declaration gets amended or how.
So when you say the number of votes, then let's just use the scenario. There's 100 homes in a neighborhood. Developer has 1 vote, and then there are potentially 99 other votes out there.
Right. It's an essential lockdown. It really
Yeah.
is.
Okay.
Or a board vote, maybe, if you had a board?
I don't know how that structure works.
Yeah.
Is that 1 vote per lot?
No.
Yeah, that can't happen.
That's a provision we need to read. And again, because of the common scheme of development ordinance, I think that there's definite room for that to be,
Yeah.
that threshold.
And that issue doesn't necessarily have to do with the way that landscaping looks or the signage look. That has to do with the way the home looks and the size and the material that's being used in it.
Brick,
Right.
hack brick side and all sides.
So on any other motion before the board, what the dues are gonna be, or what have you, whether to enforce something or not, the developer still gets, 1 vote per lot, no
Yeah.
matter what. It's when you're talking about changing the fundamental rules of the association, where the onus is to protect those folks who have bought lots already, moved in on the basis of, here's what I'm moving into. I am guaranteed the protections of this set of restrictions. But we've given that assurance already to a large extent in the common scheme of development ordinance. So simply saying the developer, the practical intent or the impact of this is once the developer sells that first lot, control is gone. Unless, of course, the developer sells it to someone like a builder or someone with mutual interest.
Is there, or could there be a provision in this that where, let's say, a developer passes away, and when lots are being sold, there's no one to look at those plans and say, yes, this is exactly what the square footage is supposed to be, this is exactly the materials you're supposed to use. If that happens, and there's not an HOA board, so to speak, what would be the way to step in and,
Good question.
I had someone ask me that, that's why I'm asking. Because that's what you're dealing with right now.
I don't have a great way of answering that, except to say that, during the first 10% of build out, let's say, the developer has all the control of the HOA. What it collects, what it doesn't collect, what it enforces, what it doesn't enforce. And let's say the people move into those first 10 houses, they don't really have any, they have some voting rights, but they're always gonna be trumped by the developer. That's why you need that shift to homeowner control. As far as getting the development reinstated, the best answer I have is that the market is gonna bring a new developer in. Getting that developer to follow the provisions of the declaration, I think the injunctive relief provided in this ordinance, and the fact that already an owner can go to court and say, this developer is doing something contrary to what's in the deed restrictions, is the only protection you're gonna get. And it's strong protection, it unfortunately involves going to court rather than going to an HOA board meeting. But that's the system that you set in order to give the developers the flexibility they need to construct.
But I'm talking, there's not an HOA board. So if you have a developer who has passed away, couldn't you go back to the Commonwealth of Kentucky, that successor and assign, so whoever would inherit that would actually therefore be the developer that would
Yeah.
go by, couldn't that be something that could be looked
Yeah,
at?
if the developer has control of the development rights.
Right.
And by whatever legal mechanism that right transfers, they're bound in the same way as though they're the developer.
And this ordinance for something that's already existing would be something that they could fall back on and say this.
Absent a provision and a declaration contrary to that, yeah.
It's already gonna be platted that way.
Right.
The restrictions are gonna be in place, that's gonna follow the property in most cases.
Exactly.
It's going to be about following those guidelines, those restrictions, and it being enforced in the right way. And that kind of circumstance is exactly what causes these problems. You get a developer who had a vision for a subdivision, wants it to be perfect, wants it to go right, and then something happens. Developer goes belly up, developer passes away, somebody else has to take it over, and that person has different interests.
Somebody still did either selling the lots or the lots were owned, and after the developer passed away, and they're not building houses according to what covenants and restrictions say.
And that's what this will stop right here though, correct?
In two different ways. Well, in
The declaration.
already, I think the citizens have the right to go to court and say, look, this is a legally binding contract between us, the homeowners, and the developer. And you're not doing that. Or please make the developer do what the document says. This goes a little bit further and says also, there's a framework for how you have to make the decisions that impact us as residents. And if they're not doing that, then they can go to court and say, they're not following that either, and it's negatively impacting us. I think there's a hand back up here.
You mentioned that the ordinance, whatever it ends up being, is not retroactive for any current situations.
Well, it is a gap filler. So, you're not really, I'm struggling to envision a situation where giving someone the right to seek an injunction on a provision in this ordinance is going to override a contract, and except where you're trying to enforce a provision that is contrary to what's existing.
Well, you mentioned a minute ago that if you have a developer in any subdivision, but say there's a developer in a subdivision, there's deeds, declarations, there's pamphlets about what the homes are supposed to look like.
Right.
There's every kind of information in the world about what the homes are supposed to look like. But the developer builds homes completely different. So what you're saying is a citizen has the right to go to court and have something done about that?
You already have that right.
What court is that?
Go to, presumably you go to circuit court. You've got
As a citizen, I can go to circuit court.
well,
It would be called filing a petition.
well, first you should,
Hire a lawyer.
you gotta hire a lawyer.
Well, if you go to planning and zoning, you don't get anything, they just kind of go blank on you. So that's
Planning and
fine,
zoning
and that's
is gonna be
fine.
out
But what
of
I'm
the
getting at is,
How so?
if
At
it,
that point.
do what?
At that point, planning and zoning is out of the picture. Because planning and zoning does not have control over private contractual matters. That's what declaration of covenants and restrictions are.
So if the homes were not built according to approved plats and declarations and everything, planning and zoning's not in.
And now, let's back that up. If the home is not built according to approved plat, something
Okay.
that the planning commission has control over, absolutely they have enforcement authority to say, stop. You're not doing this right. Setback is supposed to be 10 feet, you made it 5. Not happening. If, however, the restriction says all homes must be built of brick, and a developer comes in and builds it out of vinyl, that's not planning commission territory. That is a
Okay.
private contractual restriction that planning and zoning cannot enforce.
So it's privately handled.
Yes.
And
through the
that's
court
it.
system.
But when you first started out with this ordinance, you said this ordinance going forward, the developer will have to submit the plat for then what they want to do, what the HOA restrictions and deed covenants are, will be in that
Now.
original.
Absolutely.
And this group has to approve that. So it seems to me that it's binding on any future developer that may take over for death or whatever circumstances changes. Here's the rules that were set out originally. Therefore, you must follow these irrespective of what your vision now is for it.
Nailed it. Nailed it. The only thing I'm saying is the legal mechanism for saying to a developer, a successor to that developer who does not have the same vision, is to seek an injunction in court to say they're violating the terms of a contract.
Yes. Okay.
Rather than having the planning commission say, can't do that, that's an overstep of their authority. By state law, they just don't have it.
David, I think we were on the idea that someone could go all the way back to the beginning and change the covenants
Right.
and restrictions.
Yeah.
That goes at the heart of what our concern's
Right.
been.
No, I
A neighborhood
understand.
changing personality after we bought a house.
Yeah.
That should carry a high burden.
Yeah, yeah. You know, at one time I'd mentioned, you know, the homestead, for example. They had a really wonderful plan when they first came to Georgetown, and they were gonna do villages. As you went back a main thoroughfare, and I know I've described this before, obviously transitions have taken place in that neighborhood, but one section up front was gonna be different from a section over to the left and kind of to the rear, and then another section back behind that might be a little bit different. That's a big project, and I guess, you know, just trying to think ahead, maybe that's an unusual scenario, but why could the developer not say, okay, back in this area, we're gonna have a certain characteristic to the home, certain components, and that's not determined on the front end just because it's such a large scale project. I don't know, I'm just asking that question.
I think then that the developer's gonna have to weigh the consequences of trying to put together an entire development like that, and think through carefully what those layouts are gonna look like.
Yeah.
And may, as a result, have to scale back that project.
Do it in phases?
Well, I'm not suggesting they're doing it in phases, but you got two different levels. You got the plan review, which is the overall neighborhood, and then you got each individual plat. So it can't change from plat to plat, but if you were to do a smaller plan, you could. But we don't want to encourage smaller plan sizes. There's a reason that it's supposed to be a master plan.
Right.
The best answer I have for you is, let's say that a developer has two phases planned in this neighborhood. One's supposed to be apartment complex, one's supposed to be houses, and the other's supposed to be apartment complexes. Now, and they go to build the houses and they find out this is built on some kind of terrible, I don't know, geological formation. It's just gonna really prohibit them from building homes. It would be better if they could shift it around a little bit and build, I don't know, an apartment complex or a mixed-use facility. Then their burden is gonna be to show, look, circumstances that have a direct impact on the economic viability of the project have forced me to change this. And I think those are gonna get approved.
Yeah.
But the residents are going to be part of that process, and they're gonna be aware of it, and they're gonna have a say-so. If the facts are right, the residents should recognize, too, the circumstances that leads up to the developer's request.
And they'd have to do that in civil court, just like we would have to do that in civil
That
court.
actually is a planning commission function.
Okay, so they're allowed to do that, but they're not allowed to enforce. See, that's where I'm drawing my kinda, I understand that they don't have the power, but they have the power to do that.
Well, you're talking about a developer taking an existing plan that says there's gonna be houses here and condominiums here or whatever, and changing the condominiums to some other use. It's gonna be houses, it's gonna be mixed use. That is a function of planning commission.
To
They're
protect
approving-
his investment.
Well, the planning commission's job is to approve plans for development according to the rules and regulations in the subdivision development regulations.
Right, so when they get it wrong, what happens?
Well, depends on what they did wrong.
Here's a scenario. This happened a while ago, several years ago, where Magnolia Drive is, where the apartments are. But at that time, I think it was commercial property, and it was back when the economy was bad. You remember that, Karen? And anyway, they had attorneys, and they brought it before the planning commission. It was brought before city council, and that's where they got their zone change, the change from the commercial to the multifamily. That's how that occurred. So that's already in place, is it not? That already can happen.
Well, I think our issue is, you have a plan that the developer says, okay, well, we're going to put houses here. Like you said, there's some geological issue. Oh, well, we're not gonna do houses, we're gonna put in apartments. And that goes through planning, it gets approved, next thing you know, people with, $200,000, $300,000 houses have apartments behind them. That's an issue.
And that drives down property value.
Yeah, and that's where, with that process, what Ms. Hartley is talking about, is when it goes before the planning commission, people, the neighbors are to go over there and voice their opinion to keep that from happening. Usually they
Well,
listen.
Oh, it sucks
Well,
when
here's
you-
the thing, planning commission should automatically say no.
It shouldn't be an issue. If you're planning on putting apartments behind someone's $250,000 home, your $250,000 home.
Well, the
Wouldn't
thing
you,
is,
wouldn't
I
you wanna
just
look
went
at your
down.
planning and zoning
I don't
commission
think
and
it's
think that they have enough
geological.
brains not to do that?
Let's try to state it in
Okay.
a different way.
Okay.
Absent the provisions of the ordinance we passed in November, say the developer wanted to do exactly what you're describing. They would have to go to the planning commission and simply prove that changing the development is consistent with the comprehensive plan and zoning. That's all they would have to, prior to our ordinance. Now, they have to go to the planning commission. First, they have to send notice in writing to every single resident of the planned community. So anybody who's a part of that. They have to have a hearing before the planning commission, and at that hearing, they have to prove a change in economic development circumstances that is substantial. And the property owners would be a part of that process. And we get to weigh in front of the planning commission on whether or not that change should be allowed. That's an extra protection that was not there. Going further than that, that is the balance that we strike. Going further than that says to a developer, you get it wrong, you're just hosed. Deal with it. You have to have some flexibility in there to say to a person, you had good intentions, but some obstacle came in the way. And it's not just, well, we ran out of money. It's, we would have to spend $4 million to cut the rock out of this subdivision, out of the land here, to be able to lay out the houses in the way we want. And to say, we're not gonna make you do that, and we still want the area to be developed. So let's talk about how, let's get the community involved in how best you reshape that.
Andrew, everything you've talked about so far is for future development, right? What do we have for present homeowner associations that are not effective?
Well, another one of those things where we have to worry about reaching into existing contracts. And we kind of carefully worded what happens. You're specifically talking about common scheme of development protection.
What?
Common scheme of development, the things that we're
Right.
talking about. We created the sort of a legal fiction, if you will, of here's what the common scheme of development is in an existing subdivision. And it is everything that is there now. So theoretically, if some piece is not there yet, and it is inconsistent with what is already there, and a plan has not already been approved, then they would have to make it consistent with what's already there. Things that have already been approved, that have already received planning commission approval, either at plan or plat level, cannot be changed. that is a contractual matter that we cannot constitutionally touch. So again, we wanted to try to take a snapshot of the way things were and say, for any development that has not yet gone through that planning process, here's the new standard. So in a way, it does address existing situations that have not yet started through the planning process.
Well, Kurt's got a question. Go ahead, Kurt.
Okay, let's talk about HOAs that aren't HOAs. What are we gonna do about that?
That's next. That's the next slide, look. By plat and or deed say an HOA is responsible for maintenance of common areas, but there is no HOA because A, the developer never created it, or B, the residents voted to disband it. And both those things are true in different neighborhoods here in the city of Georgetown. So, amongst all the other provisions, we've already touched on a few provisions that kind of fix this in a way, but here are the two that help with those two situations. Our stormwater post-construction ordinance, which we passed, first ordinance we passed last year, says, importantly, maintenance of stormwater BMPs in new neighborhoods is the responsibility of an HOA. This is in new neighborhoods. So any new subdivision that is planned that has BMPs, and they're all gonna have them, is gonna be the responsibility of an HOA. And the developer has to create that HOA before the first shovel of dirt is turned. So that HOA in turn has to sign a contract with the city saying, we promise to maintain that stormwater infrastructure. We promise to do the maintenance, we promise to mow it, we promise to do whatever it is that we have to do according to these standards that we passed. So you're not ever gonna have the situation where an HOA doesn't get created. It just can't happen. Planning Commission will not sign the plat until they're presented with the HOA documents. Now, that doesn't mean that the residents couldn't immediately go and vote to terminate, or the developer could vote to terminate. So we put a provision in that says, cannot terminate an HOA unless provisions are made for maintenance of the common areas, and that's gonna include stormwater. And we, as the city, and you as the residents, would have the right to go to court and say, can't do it. Ordinance says you can't do it. And finally, there is a process on that balance between government reach and private interests. There is a provision allowing the residents of a neighborhood to go and restart a defunct HOA. I wrote down the notes here about what those provisions are. First, what you're essentially doing is you're creating a plan for new covenants and restrictions. And those covenants and restrictions cannot be any more strict than what was already in place or should have been in place. They can be less strict. If after 30 years the neighborhood decides all it really wants to do is to mow the common area and not worry about whose house is what size or what color or whatever, whose mailbox is offensive, then you can say, all we're gonna do is maintain common areas, and it's gonna be a $5 a month fee or $5 a year, whatever it takes to mow that field or maintain that stormwater infrastructure. It takes no less than 3 members to form a committee. That committee has to give notice to every resident. Here's our plan for reinstating the HOA. There has to be a vote, and at least 10% of the residents vote to approve doing that plan.
Did you say 80? I'm sorry.
10%.
10%.
And that is a number that we massaged. Because we want to encourage residents to reform HOAs. That should be there. This provides a mechanism that is in an ordinance that says if you had an HOA but you don't have one now, here's how you go to create it. You don't have to go to court. You don't have to petition a judge to say there's a new HOA. You go through this process. It's approved by the neighborhood, it gets filed in the courthouse, you got an HOA. So that's how defunct HOAs get revived into the terms of our ordinance.
How do you collect the assessments? Is there any teeth in that at all?
Absolutely, there's the same.
Except for
teeth.
putting a lien on somebody's house?
You're not gonna get that in any, you're not gonna get beyond putting a lien on someone's house in any operating HOA in this country. That is the mechanism.
I understand. My point being, you've got 200 plus homes, let's say. 10% of them say, let's do the HOA. 150 of them say, I'm not paying you a penny. How you gonna maintain the common area with 50 people paying $5 a month?
Right.
That's my point. Because that lien goes on that house, you've got two choices. You can foreclose, or you can stay there till the house sells.
Right.
And it could be 20 years, and that money, you'll never get that money.
Well, I'll tell you one thing, and I've struggled with this question myself. Because I've been asked to do similar things based on people not mowing their grass. City had to go in and mow your grass, but we want to ask the court to foreclose on you? Well, I don't know. Good news is for the city, we get paid eventually. But I guarantee you got 100 homes, and only 25 of them are paying their dues. You foreclose on that first house, one house, and all of a sudden the rest of them are paid too.
Well, you're right. That's true. Okay.
The problem you get into though, Andrew, is the situation he's talking about. If only 25% of those people are paying, you don't have enough money coming in to do the mowing.
Exactly right.
Somebody has to kick in enough to cover it.
Point.
Now you don't have any money to hire a lawyer to go sue the people.
Sure. Well, I think if you look, you'll find an attorney who's willing to say, I'll take this case based on getting a contingency. Because a court would award them fees. An attorney would look at the case and say, the law is clear. You have to maintain this. You have to have this HOA. You have to pay your dues. I'll take that case. And I'll take them to court and I'll get my fees back and you won't owe me a penny.
Right now, you don't have anything, at least it's something, you know?
I mean, I hate to be that blunt about it.
Well,
but
you do.
That's the reality
You do
of the
right now.
legal
I'm
system.
sorry?
You do right now. You have that same recourse right
Yeah.
now.
Yeah.
Yeah, but you don't have any income right now in the colony?
No.
I mean, I think
We as,
that's,
we as a city can't force any HOA that's defunct to go forward. It's up to the citizens that's in that neighborhood.
Yeah,
And that's not our
I'm not-
position to make you have an HOA. We would love for you to have it.
I was gonna ask, did the colony ever even have one? We just moved there.
1987, there was one that was never active.
Okay.
I think that's the one they voted to disband.
Is that right, Kurt? 1987?
disband?
To disband. They actually
Yeah.
took a vote, said, we hereby dissolve the HOA.
Within that same year or so.
Well, then it's dissolved.
Yeah, it has to be reestablished.
It does, absolutely. And actually, this entire provision is stolen from Florida state statutes, where they have the same problem. And if you know anything about Florida, everything south of Orlando is deed restricted community. And you have situations, especially in the smaller communities, where the HOAs fail. They stop, they have so much turnover, they stop electing board members, they stop upkeep, but the pools need to be maintained, and the entrances need to be maintained. And when you're talking about condos, you're talking about things like elevators and porches and community centers and all that stuff. There's got to be some provision for saying, it's supposed to be there, let's revive it. And we're trying to provide you with that mechanism. Now, the city could have put a provision in there saying, we have the right to go to court and reform that HOA. We felt that was a little too far. But we did say, if you got a large common area, like you got, for instance, in the colony, there is a sizable lot that has a retention pond on it, that has quite a bit of vegetation, and it can attract unwanted wildlife. If the city has to come in there and do an abatement, we have to to mow it, or we have to dredge the pond, or we have to, whatever it is that you do, especially if it's a stormwater feature, we're gonna come in there and we're gonna do the maintenance that's required under our nuisance code, or under the terms of the stormwater post-construction ordinance. We are gonna go to court and say to a court, appoint a receiver that will act as the HOA, that will collect the dues from the residents in an amount, only in an amount sufficient to pay back the city for its cost of abatement. And if it's an ongoing cost, we have to come in once a year and dredge your pond. And we would have the right to ask the court to make that receiver indefinite until the residents say, you know what, we've had enough of paying the fees of a receiver. We'd like to just pay our own bill and substantially reduce that bill and take care of what we're supposed to be taking care of. So that was kind of our middle ground, because we have an interest in seeing that those common areas are maintained, especially when it comes to stormwater. You know, tall grass is one thing. I think it's supposed to be mowed. And the city has made the decision in the past to mow common area that didn't belong to it, in the interest of public health and safety. And I'm not saying that won't happen again. It's gonna be part of the code enforcement process. And the city ought to have some recourse other than trying to put a lien on property that can't be sold or developed. So that's that. I have 2 more slides, and that's basically just, I really already covered it. The stormwater post-construction ordinance requires an HOA to manage stormwater. You have to sign a maintenance agreement. Developer has to create the HOA and record those stormwater covenants prior to plat approval, which means prior to shoveling dirt. And the responsibility for the maintenance must be borne proportionally based on lot sum. That's a hard and fast rule. Now there's provisions in there allowing the owners to say, you know what, our lot is bigger, or especially in a commercial situation, if it's gotta be borne equally, that could create problems. There's still an equal responsibility, but the two could get together and you can contractually say, you know what, we only want to be responsible for 2/3 of that, because we have a 2/3 size lot, and we contribute more stormwater. That's okay. But when we have to come after it, when we have to come after the property owner for responsibility, it's equal.
Could you define for me BMP?
It's a stormwater best management practice.
Okay, best, all right, thank you.
That's a fancy term for
Not
things
spelling it out.
like, fancy term for things like drainage ponds or infiltration systems. That big fancy underground drainage system they put in front of the Family Dollar, that's a stormwater BMP.
Okay.
It's a technical specifications for controlling stormwater.
Probably the largest BMP that any of you have ever seen is at the corner of US 25 and the bypass beside the hospital.
Yes.
That is one
Big,
giant
that's a
drainage.
big BMP.
It's the biggest BMP I can point out to you.
But what it does, it just controls the water as it slowly goes down to keep it from flooding. That's what it is.
Yeah.
And the terms of our subdivision regs have called for those kinds of items to be put in for 20, 30 years now. I mean, it's part of basic engineering is requiring that, but there has never been an indication in any document that I could find which says who's responsible. There's not an indication, or there wasn't until we passed this ordinance, as to who's responsible once those things are created. We've said, based on our ordinance 15001, on all new subdivisions, the property owners are jointly responsible for the maintenance of those common areas.
I'm sorry, can I ask you something? So you said like, some of the HOAs that have been disbanded, you can, start them up again, you can't make them those original restrictions then?
Well, the good news is, in the Colony's case, they're all there. They're all filed in the courthouse.
Okay.
All the deed restrictions are there, they just aren't being followed.
Okay.
If you go over there and talk to Carla at the courthouse,
She can pull them all up.
Everybody knows
She'll
Carly.
help. Carla Everett. If you go in where the deeds are, they've got computers set up and stuff, but,
Just print them out? or something?
yeah, and she'll help you do it.
Okay.
She's very nice.
Everybody here is very nice.
Worst case scenario, you can't get the HOA formed. You can't get 10%. Is the city prepared to do the receivership and, like you said before, to get their money back?
I think if we pass the law, we better be prepared.
Okay. I'm just saying that because there's got to be some teeth. That's what I'm getting ready to say.
Sure.
So what he's referring to, the colony has always been, since we got several colony people here, in the colony, it's always been an issue. So if folks are gonna try it and they can't make it happen, then the next step for us to mow and maintain and do all that is going to,
Cost them more.
It should be just like the regular nuisance code enforcement provisions. Give you a 10-day notice to correct. If you don't correct it, we do it. You file a lien, and then we go to court and ask for a receiver.
But who would you send those notices to then? For the colonies?
Good question. Well, there is an owner of record in the deed. I mean, the deed says so-and-so, care of the Colony Homeowners Association. So in that case, what the law would say to us, we have to appoint what's called a warning order attorney. And it's kind of a legal mechanism for saying we can't get in touch with, I, the warning order attorney, have done everything within my power to try to get in touch with the person responsible. We can't do it, and the court basically recognizes there isn't one, and one is legally assigned. And ownership interest is legally assigned based on. You have a contract, no different really than a mortgage. You have a contract that says X is responsible. Now, I will say, interestingly, that a similar private suit was brought in the one over there that we met at the fire station.
Oh, yeah. Oh, no. Georgetown lady?
Bradford?
Bradford.
Bradford.
The residents there actually brought suit against the developer, and the court said, you gotta bring suit against everybody. There's a chance the court would say that to us, in which case, we have to name every single resident in that neighborhood. I hope that doesn't happen. I think that we've set up a structure to basically say, look, here are the people who are responsible on paper for that. We're not, and we have no trouble with giving notice, but the idea is to get that interest, those people's interest, which is supposed to be represented through an entity, before that court. So I'm not sure how the court would handle that, but.
but in the colony, see if I can, I tell the mayor this is lawyers, but in the colony, for instance, that one, since the person that started is deceased, and like you said, time has moved on, and they can't, the citizens want to, but they can't get the threshold needed to get it started. And the common grounds and the sign and all that's falling apart, so the city goes in and fixes it. So we're putting, then we would take the whole community to court? Is that what we're
Well,
doing?
I'm hoping that you don't. I'm hoping that you don't do that. What the ordinance says is, the common area is there for the benefit of the entire neighborhood. And by contract, every owner is contractually responsible for its maintenance through the mechanism of assessing fees. So we would be asking the court to basically say, some person would assess those fees, but only to the extent necessary to reimburse the city. We're not, I hope it doesn't get construed to, we're taking every citizen to court. No, we're taking the entity that should be responsible for that maintenance, the homeowner association, to court.
But by there not being a homeowner association, then we are actually taking the neighborhood, of course, you take however many houses out there, you're not talking about much, but nevertheless, you're taking the neighborhood to court.
You are.
Is what you're doing.
You are, but there's no provision in there that says we have the right
but then they're still gonna be taking up the slack for the rest of the neighborhood.
those that
They don't
don't.
care, you're not gonna lean on them.
How many-
No, I think he's got a point. You do put a lien on it. Yeah, you foreclose on that first person. Yeah, you drop them down on
I
them.
mean, that's kind
If
of
they're not
like-
gonna do it, then, you know, I mean,
The thing is, that's how it has to work everywhere.
Everywhere.
And it's a big leap, yes.
right.
But in every other functioning HOA, when a citizen doesn't meet their obligation under the terms of the HOA, let's say they build a structure that is in violation of the deed restriction, that HOA has to take them to court. Either has to go and they can tear it down, or they can file for an injunction or whatever, but they may have to foreclose if they don't pay their dues. If a well-functioning HOA, one resident doesn't pay their dues, the only recourse that HOA has is to slap a lien on their property. And either they will foreclose, or when the house gets sold, they'll get their money.
Right. Well, and you also, there's the option of, when you just brought up the structure, and it's not, you know, if you put a pole barn on your property or whatever the situation may be. You know, I don't foresee it being much of an issue for the HOA and the colony, so long as it's cutting grass and stormwater.
And that's
Yeah.
about all there is
You know,
to maintain out there.
Right,
is
you know,
stormwater
so
and
we don't want
grass.
somebody, I mean, 90%
Well,
of
you've
the
got the
people we've
in-
talked to and heard, don't want somebody on their property saying, your grass is 3 inches tall instead of 3 1/4, whatever.
No.
You know, and want somebody out there with their measuring stick.
Well, currently,
That's what
the
they're worried
entrance
about.
sign is maintained by Haverford. Haverford, they pay Hillemeyer's to mow the entrance and plant fires at the entrance. The the townhome complex built the sign, they've replaced it once. And then going down the main boulevard, the homeowners mow it. All the way down, they get out in their mowers and mow it.
We're trying to create the circumstances for a neighborhood like the Colony to be able to self-organize and say, let's assess ourselves in a very reasonable amount to the extent that is necessary to take care of our common area, not to, rule with an iron fist over how tall your grass is or what color your house is. Just to keep those common areas mowed, and if it's mowing common area 10 times a year, paying somebody, even if it's $300 a time to mow that area 10 times a year, that's what, $3,000, right?
Mm-hmm.
How many homes are there?
How many homes are there? You could have a fee of $5 a year and take care of it.
There's a question in the back.
Yeah.
Andrew, let me ask a question. I live over in Bradford. I am under the assumption that some of those homes are part of an HOA and some are not. My sales contract, when I bought it, said no HOA, but my neighbors have it. How's that gonna work?
Well, there's some things that I don't think we can address. I think we've thought a lot about issues like that, and we've tried to prevent that kind of thing from happening with our common scheme of development ordinance. But where a developer was supposed to put in deed restrictions and didn't, or set arbitrary lines between what properties do have deed restrictions and what properties don't, the only resolution you're gonna get there is a private civil suit. And that's what happened in Bradford, is my understanding, is they sued the developer to say, you should have put these in there. And the court said, you gotta sue everybody, because all their property interests are affected. Now, that's extreme to me, but I'm not a judge.
Right, but, I mean, where do we find what those deed restrictions should have been? I mean, there was never an HOA on my house
In
from
the eyes of the
12
law,
years ago.
in the eyes of the law, there's no such thing as what deed restrictions should be. In the eyes of our ordinance and what's in the courthouse, there's no such thing as what should have been. That's really a contractual matter. You can go to the courthouse, pull up the deed restrictions that are there for your property, and if they can be tied in the chain of title back to that property, then legally speaking, that property is bound by those covenants and restrictions.
Andrew and I met with the officers of the Bradford Homeowners Association, and we reviewed with them their circumstances, which are pretty drastic, I think. You've got 1/3 of the homeowners up there as a part of the HOA and paying dues for the benefit of the entire subdivision. And so 1/3 is paying for the 2/3 that aren't paying. When we met with the officers of the Homeowners Association, they were wrestling with the very difficult question about whether they wanted to sue 2/3 of their neighbors. And I'm not sure they had the appetite for that. I don't know what their final decision was.
That's so like, we don't have that appetite either. If we,
So, we understand how difficult that is, and to your question, the real difficulty here is whenever we look backwards.
Oh, yeah.
And we look at correcting issues, and, we wanted some language in there that would give you a hope of being able to do that if you were motivated to do so. And we tried to make the thresholds low enough to where you could perhaps be successful. It's such a better outcome if a functioning HOA takes care of these matters prospectively. Because you're right, ultimately, the city can come in, but we only come in when it's become a nuisance. It stopped being pretty a long time ago.
Yeah.
It started being okay for you to live around a long time ago, and it's gotten to a nuisance level now. Then we can come in, and that's not the way we want your neighborhoods to be treated. We'd rather it be done on a more prospective basis and kept current.
Well, about 10 years ago, there was 5 or 6 homeowners, which I was one of, that worked probably for 6 months with the developer, trying to get it established, the HOA established. We even made a budget. We even drew up new covenant, revised covenants and restrictions. And we put a mailing list. We mailed every owner in the subdivision. And we had a meeting over at the flea market where the bingo hall is. It became a bloodbath. It did. It became a bloodbath. I mean, there was so much. And we even had attorneys there. We had everybody there. And they just, certain areas and certain streets absolutely refused. And they were gonna do this and they were gonna do that. So my point is, we've had some experience with this, and I got a feeling of what's gonna happen when we do it again. But now, you do have you will have some ordinances that we can rely back on.
But we're also trying to make that load lighter.
Yeah,
If what
right.
you're talking about is reinstating 30-year-old deed restrictions that say this and that use is prohibited, you're gonna have an uprising.
Yeah, we didn't do that, though. We rewrote them as it would be today, but that's 10 years ago.
But if what you're saying is you gotta pay $10 a year to mow the common area, I think people might be a little upset about it, but they're not gonna blow up.
Oh, we did.
I have faith that would not happen.
When you asking for like $50 a year or something?
100 a year. That's what the budget ended up at, 100 a year.
With this Bradford Place situation, wouldn't he have the right to get 10 or 20 residents and organize a new HOA for that, the remainder of that area, under this
What the
ordinance?
ordinance says is where there was a previous existing declaration and a previous existing association, and that association has no longer functions, they can revive it. It does not and cannot address what happens where there should have been deed restrictions and never were. That's a civil matter. If the deed restrictions were put in place and an HOA was never formed, I think that it would allow them to do that. Yes.
That's an avenue for you.
I'm happy the way it is.